That phrase, subject to the jurisdiction thereof, is the legal crux of the entire controversy. Birth tourism is real. It's a growing industry. That approximately 33,000 births per year to women on tourist visas. Stop pretending an executive order can overturn 158 years of constitutional law. It cannot. The 14th Amendment was written in the blood of the Civil War. That principle is worth defending. The right answer is not a shortcut. It is an honest constitutional conversation. March 6, 1857. The Supreme Court of the United States handed down what legal scholars almost universally consider the worst decision in its entire history. A former slave named Dred Scott had been taken by his master into free territory. In the free territory, Dred Scott had lived as a free man. He had worked, built a life, and he sued for legal recognition of the freedom he had already been living. The case made it all the way to the highest court in the land. Chief Justice Roger Taney, writing for a 7-2 majority, ruled that it did not matter because Dred Scott's ancestors had been enslaved. He was not a citizen of the United States. He had no rights that any white man was bound to respect. He was property. Today, I'm going to tell you what most Americans have never been told, what the 14th Amendment was actually written to do. Why the birthright citizenship debate is more complicated than either side admits, and what common sense looks like when we stop letting politicians use the Constitution as a campaign prop. Welcome, patriots, to Common Sense for America. I'm Bruce Rutherford, your host and commentator, coming to you from the beautiful Westwood Golf Club in Houston, Texas. This is the fourth and final episode of our series. After 3 episodes looking at America's role in the world, we come home to a constitutional question that goes straight to the heart of who we are and what we stand for as a nation. If you're watching on YouTube, please like this video and subscribe. If you're listening on one of our podcasts, please subscribe and leave us a rating. Now let's get into it. Both sides of the birthright citizenship debate are partially right, and neither side is telling you the full history. Abraham Lincoln campaigned against the Dred Scott decision and understood what was really at stake, not just for Black Americans, but for the principle of equal citizenship itself. If the court's logic held, Lincoln argued, then the words, "all men are created equal," in the Declaration of Independence meant nothing. After the Civil War, the Republican Congress passed the 14th Amendment, specifically to make Taney's ruling impossible forever. Place the principle of birthright citizenship on a foundation no future court, no future Congress, no president could legislate away. Now here is the history in plain terms. Chief Justice Taney ruled that people of African descent were not included and were never intended to be included under the word citizen in the Constitution. They had no rights, which the white man was bound to respect. Chief Justice Charles Evans Hughes later called it the court's greatest self-inflicted wound. The 14th Amendment, ratified in 1868, contains 38 words written specifically to correct that ruling. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Written in the aftermath of the Civil War, written so that no future court could ever again look at a child born on American soil and declare them a non-person. That phrase, subject to the jurisdiction thereof, is the legal crux of the entire controversy. President Trump's argument to the Supreme Court is essentially this: a child born to parents who are tourists, who came here specifically to give birth and take their child back to China or Russia or wherever they came from, that child is not truly subject to American jurisdiction in any meaningful sense, in any meaningful way. Their legal relationship is to a foreign government. The 14th Amendment was not written to cover that situation. There is something to that argument now. There really is. Birth tourism is real, and it's a growing industry. The Center for Immigration Studies estimates that approximately 33,000 births occur per year to women on tourist visas. These are documented realities, not hypothetical concerns. But here's where I want to be equally honest. Over 70% of undocumented immigrants who had children born here, who had lived in the United States for at least 5 years before that birth. The 14th Amendment protection of those children is a much harder case to argue against. I do not think Trump can win the broadest version of this argument in the courts. The Supreme Court upheld birthright citizenship in 1898 in a case called the United States versus Wong Kim Ark. Don't ask me for the details of that. I don't know. 158 years of constitutional law does not yield to an executive order. Edmund Burke, he said, "A great nation and little minds go ill together." The birthright citizenship debate brings out small thinking on both sides. One side treats the 14th Amendment as so sacred it cannot even be discussed. The other side treats an executive order as a legitimate substitute for the constitutional process the founders established. Both positions are wrong. Honoring the principle and fixing the genuine abuse are not in conflict unless we let politicians turn a constitutional question into a campaign slogan. Honor the principle, fix the genuine abuse, use the right tool to do it. Address birthright tourism directly through targeted legislation that goes after the commercial industry, the agencies, the maternity hotels, the visa fraud operations that produce these births. What can be done? That can be done without touching the 14th Amendment at all. For the broader question, what is subject to, quote, the jurisdiction thereof, what does that mean in a world the founders never imagined? We must pursue a constitutional amendment to sort that out. We must make the argument honestly. A constitutional amendment could define the words subject to the jurisdiction thereof and limit birthright citizenship to children born to parents who have lived legally in the United States for at least 3 years. One of those parents is at least in the process of pursuing United States citizenship for themselves, and both have pledged allegiance to the United States, even if it's not done until the day their child is born. Let the American people weigh in through their representatives. That's how a republic is supposed to work. And stop pretending an executive order can overturn 158 years of constitutional law. It cannot. The courts have already said so. Continuing down that road wastes political capital that could be spent actually solving the problem. So here's what you need to remember. The 14th Amendment was written in the blood of the Civil War to make certain that no child born on American soil could ever be declared a non-person by the state. That principle is worth defending. So is the integrity of American citizenship and the constitutional process the founders gave us for resolving exactly these kinds of questions. The right answer is not a shortcut. It is an honest, constitutional conversation that treats both the principle and the problem with the seriousness they deserve. That is what this series has been about from the beginning. Not the easy answer, not the politically convenient answer, the common sense answer, even when it's a lot harder than a bumper sticker. Thank you for watching all 4 episodes. Please share this series with someone who needs the full picture. And tell me in the comments, where do you come down on birthright citizenship? I read every comment and I want to hear from you. Until then, may God bless you and yours, and God bless America.